Hello everyone, today we will talk about the arrest warrant of the 11th of April in 2000. The members of our group are Belen, Alba, David, Arancha and myself. First, let's go through our index. The first step will be to explain the facts of the case. The second one will be to see which claims each party brought to the case and which legal provisions are they following. The third part is going to be the legal reasoning followed by the court in order to solve this case. In the fourth one, we will explain what the sentence was and the conclusions done by the court. And the fifth and last part of our project will try to explain you why this case is important for our class of diplomatic law.
The 11th of April of the year 2000, a Belgian judge issued an arrest warrant against Mr. Abdoulaye Yerodia, seeking his provisional detention, pending a request for extradition to Belgium for alleged crimes constituting serious violations of international law. By that time, Mr. Yerodia was the Minister of Foreign Affairs of the Democratic Republic of Congo. The judge who issued the warrant did it claiming that Mr. Yerodia had not only violated several articles of the 1949 Vienna Convention and its first and second protocols, but also had committed different crimes against humanity. Apparently, Mr. Yerodia's speech incited the Hutu population to attack the Tutsi minority. Belgium sent the arrest warrant to the Interpol in order to ask all member states to intercept, arrest and extradite Yerodia to Belgium. It is noteworthy to know that after Belgium issued the warrant in November 2000, Mr. Yerodia became the Minister of Education, and that by the time the judgment took place, Mr. Yerodia was not holding any official ministerial office anymore. The 17th of October of the year 2000, the Democratic Republic of Congo filed an application to the court instituting proceedings against the Kingdom of Belgium in respect of the dispute concerning the aforementioned arrest warrant. In the application, the Democratic Republic of Congo claimed that the Kingdom of Belgium had violated the general principle that a state may not exercise its authority on the territory of another state. Also, Article 2, Paragraph 1 of the United Nations Charter, which says that all member states shall enjoy sovereign equality. Moreover, Article 31, Paragraph 2 of the Vienna Convention on Diplomatic Relations of 1961 regarding the diplomatic immunity of the Minister of Foreign Affairs of a sovereign state. The final answer by the ICJ wouldn't arrive until the 14th of February of the year 2002.
Following the international arrest warrant, the Democratic Republic of Congo presented a claim against Belgium supporting themselves on the Declaration of Acceptance of the International Court of Justice, Article 36.2. The legal grounds brought before the ICJ by the Congo are the following. According to the Article 2.1 of the UN Charter, the sovereign equality of states has to be respected. According to this article, the Congo states that the universal jurisdiction used by Belgium is void. Moreover, Article 41 of the Vienna Convention on Diplomatic Relations goes against the Article 5 of the Belgian law. Article 41 says that the immunity of the Minister of Foreign Affairs has to be respected. According to Article 40 of the Statutes of the ICJ, the Congo illustrated the fact that Belgium had accepted the jurisdiction of the court. Therefore, Belgium has the obligation to appear before the court as well as, insofar may be required, to accept and respect the jurisdiction. The maybe most important legal ground which supports the Congo's claim against Belgium is international customary law. The Congo states that Belgium committed a violation in regard of the rule of customary international law concerning absolute inviolability and immunity from criminal process of incumbent foreign ministers. Overall, the Congo challenges the legality of the arrest warrant on two legal grounds. First, Belgium's claim to exercise a universal jurisdiction, and second, the violation of the immunities of the Minister of Foreign Affairs of the Congo that held office at that time. The Kingdom of Belgium, rejecting the application of the Congo at the ICJ as well as the court's jurisdiction over this case, based its defense on the following legal grounds. Initially, the international arrest warrant has been issued because of Mr. Yerodia's violation of the Geneva Convention and its additional protocols, who held the position of director officer at the time of the wrongful act. due to the various speeches provoking racial hatred during the month of August 1998. Furthermore, according to Article 5 of the Belgium law, the immunity attaching to the official capacity of a person, in this case Mr. Joredi, shall not prevent the application of the present law. Additionally, Belgium states that according to Article 7 of the Belgium law, as well as the principle of universal jurisdiction, Belgian courts shall have jurisdiction in respect of the offences provided for in the present law, whosoever they may have been committed. Moreover, Belgium brought up the Northern Camerons case, in which the court found that it only may pronounce judgment only in connection with the concrete cases where there exists at that time of the adjudication an actual controversy involving a conflict of legal interests between the parties. Also, the conclusion of the nuclear test case stated something similar. The dispute brought before the court must continue to exist at that time when the court makes its decision. Overall, the Kingdom of Belgium does not deny that a legal dispute existed in the past. However, Belgium now states that there is no longer a legal dispute with the Congo, because Mr. Yerodia is no longer occupying a ministerial position. Therefore, there is no longer a legal dispute between the parties, and the court shall decline to proceed to judgment.
After knowing what exactly each party claimed and the presentation of legal provisions, we are going to make a legal reasoning regarding the different objections made by Belgium and the Democratic Republic of Congo. Firstly, we're going to start with the objections that have less importance and relevance because they were rejected at the beginning of legal proceedings due to lack of arguments and legal support. One of the objections provided by Belgium was that the International Court of Justice did not have competence and jurisdiction to rule the case. This attempt made by Belgium is really common in international public law cases because if the ICJ does not have jurisdiction indeed, the case is automatically cancelled. However, this is not the case. According to Article 36, Paragraph 2 of the Statute of the Court, the state parties to the present statute need to approve the jurisdiction of the court in legal dispute concerning the interpretation of a treaty, any question of international law, the existence of a breach of an international obligation, and the reparation in case of that breach. The 17th of October of 2000, the date that the Congo's application was filed, both Belgium in 1958 and the Democratic Republic of Congo in 1989 accepted by declaration the jurisdiction of the ICJ. So, this objection made by Belgium was rejected. Another objection made by Belgium was that as in November 2000, Mr. Yerodia ceased to hold office as the Minister of Foreign Affairs and became Minister of Education, Congo's application had become moot, is not relevant anymore, and the ICJ shall remove it from the list. However, the court recalls that at the time that the arrest warrant took place, April 2000, Mr. Yerodia was Minister of Foreign Affairs. Therefore, it doesn't matter where Mr. Yerodia holding office after or at the moment. What matters is the lawfulness of the arrest warrant. The last objection made by Belgium that was rejected refers to Article 40, Paragraph 2 and 3. These paragraphs state that the registrar shall forthwith communicate the application to all concerned, and that he shall also notify the members of the UN through the Secretary General and also any other state entitled to appear before the court. In this case, the application was forthwith communicated to the government of Belgium by the register, and also in accordance to paragraph 3, all states entitled to appear before the court were notified of the application. So, that's why another Belgian claim was rejected. Now, we're going to analyze the important issues of the legal reasoning. In the application instituting these proceedings, the Congo originally challenged the legality of the arrest warrant on two separate grounds. On the one hand, Belgium's claim to exercise a universal jurisdiction, and on the other, the alleged violation of the immunity of the Minister for Foreign Affairs of the Congo, then in office. However, in its submission and memorial, Congo just invokes only the latter ground.
Universal jurisdiction. International jurisdiction is understood as a legal principle which allows or requires a state to bring criminal proceedings in respect of certain crimes, irrespective of the location of the crime and the nationality of the perpetrator or the victim. The idea behind it is based on the notion that certain crimes are so harmful to the international interest that the states are obliged to bring proceedings against the perpetrator, regardless of the location of the crime and the nationality of the perpetrator or the victim. Universal jurisdiction allows for the trial of international crimes committed by anybody, anywhere in the world. Principles such as audedere aut judicare, which means extradite or prosecute, have been really effective when promoting that the states implement the principles of universal jurisdiction. Regarding our case, in the arrest warrant, Mr. Yerodia is accused of having made various speeches which could lead to racial hate. The crimes with which Mr. Yerodia was charged could be punished in Belgium under the law of 16 June 1993, concerning the punishment of grave breaches of the International Geneva Conventions of 12 August 1949 and of Protocols 1 and 2 of 8 June 1977, as amended by the law of 19 February 1999, concerning the punishment of serious violations of international humanitarian law. Article 7 of the Belgian law provides that the Belgian courts shall have jurisdiction in respect of the offences provided for in the present law, wheresoever they might have been committed. According to Belgium, the complaints emanate from 12 individuals all resident in Belgium, 5 of whom were of Belgian nationality. It's not contested by Belgium, however, that the crimes were committed outside Belgian territory. Mr. Yerodia was not a Belgian national at the time of those acts. Mr. Yerodia was neither in Belgian territory at the time the arrest warrant was issued and circulated, and no Belgian nationals were victims of the violence that was said to have resulted from Mr. Yerodia's crimes. Democratic Republic of the Congo relied on the following separate legal ground. Universal jurisdiction that Belgian states attributes to itself under Article 7 of the law in question constitute a violation of the principle that a state may not exercise its authority on the territory of another state and of the principle of sovereign equality among all members of the United Nations. As a subsidiary argument, Belgium further contends that, in the event that the court decides that it does have jurisdiction in this case and that the application is admissible, the non-ultra petita rule operates to limit in the jurisdiction of the court to those issues that are in the subject of the Democratic Republic of the Congo's final submissions. The non-ultra petita rule is an emanation of the general principle that an international tribunal's power are limited to what is conferred upon it by the parties. Belgium points out that the Democratic Republic of the Congo advanced an argument based, on one hand, on the Belgian judge's lack of jurisdiction, and on the other, on the immunity from jurisdiction enjoyed by the Minister of Foreign Affairs. According to Belgium, the Democratic Republic of the Congo now confines itself to arguing the latter point, and the court consequently cannot rule on the issue of universal jurisdiction in a decision it renders on the merits of the case. The court recalls that the well-established principle that it is the duty of the court not only to reply to the questions as stated in the final submission of the parties, but also to abstain from deciding points not included in those submissions. The non-ultra petita rule cannot preclude the court from addressing certain legal points in its reasoning. In the present case, the court may not rule on the question whether the dispute arrest warrant issued by the Belgian investigating judge in exercise of his purpose of universal jurisdiction comply in that regard with the rules and principles of international law governing the jurisdiction of national courts. This does not mean, however, that the court may not deal with certain aspects of that question in the reasoning of its judgment, should it deem this necessary or desirable. To conclude the reasoning, by the law of 10 February 1999, the Belgian Parliament amended the Act of June 16, 1993 to include crimes against humanity and genocide, along with war crimes already regulated since 1993, in regard to the ICJ, with agreement at this point indicated by the Democratic Republic of the Congo and Belgium. The side pursuant to the non-ultra petita rule the following. In the present case, the court may not rule in the operative part of this judgment of the question whether the dispute arrest warrant issued by the Belgium investigating judge in exercise of his purpose of universal jurisdiction, that complied in regard with the rules and principles of international law governing the jurisdiction of national courts.
After analyzing the universal jurisdiction principle, we are going to talk about the immunities and the inviolability of a Minister of Foreign Affairs. The Court contemplates at the outset that in international law, generally, it is established that certain holders of high-ranking office in a state, such as the head of state, head of government, and Minister for Foreign Affairs, enjoy fully immunity from jurisdiction in other states, both civil and criminal. In the present case, the immunity is only applicable for criminal jurisdiction due to the nature of the accusations. According to Article 5, Paragraph 3 of Belgian law, immunity attaching to the official capacity of a person shall not prevent the application of the present law. However, this application constitutes a violation of the inviolability and immunity from criminal process of an incumbent foreign minister. It is true that several treaty instruments are cited. As we all know, international treaties are the primary legal source of international public law, according to Article 38 of the ICJ. The Vienna Convention on Diplomatic Relations of 1961 and the New York Convention on a Special Mission of 1969 are some of the examples exposed. However, these conventions show a guidance on some aspects regarding immunities of different ages of the state, but in any of them, there is a specific provision for immunities enjoyed by the Minister of Foreign Affairs. Therefore, customary law, another legal source established in the Article 38 of the ICJ Statute, is the basis chosen by the Court to decide the questions relating to immunities in this case.
Immunity versus impunity. Here we have two concepts that usually are considered synonyms, but we're going to show you the difference between them. The first one is immunity. This concept means that an individual or an entity cannot be held liable for a violation of a law. In our case, Yerodia, the former Minister of Foreign Affairs, is granted with immunity by his country, the Democratic Republic of Congo, and due to this, Belgium has no issue claiming an arrest against him. On the other hand, we found ourselves with impunity. Impunity is an exception from punishment. In international law of human rights, we refer to this as the failure to bring perpetrators of human rights violations to justice. In our case, the ICJ declares that Yerodia enjoys immunity. However, he is not scot-free from his actions. There are four possibilities for him to be judged. The first of these possibilities is that the courts from his own country, the Democratic Republic of Congo, can condemn him because, according to the domestic laws, he can be punished by his actions. The second reason will be like if the state renounces to grant protection to Yerodia, he can be judged because he's not enjoying immunity anymore. We have to remember here that because diplomatic protection is a discretionary power of the state, only the state can give it and take it away. The third reason is that the individual is working as the Ministry of Foreign Affairs, so his actions during this term grant him immunity because they are official acts. So when he is no longer Ministry of Foreign Affairs, all of his actions can be judged by the courts from their states. Fourth possibility. The criminal responsibility of the individual can be enforced before the courts if these courts have international jurisdiction over it, if the statute that created them grants them with.
Despite Belgium's objections claiming that Mr. Yerodia was not a minister anymore, the court declared that Belgium had failed to respect and infringe Mr. Yerodia's personal immunity as a foreign minister. Firstly, after examining the terms of the warrant, the court concluded that by seeking to arrest him in order to try him for charges such as war crimes and crimes against humanity, the Kingdom of Belgium failed to respect the immunities of the incumbent Minister of Foreign Affairs of the Congo, and more specifically, had violated the immunity from criminal jurisdiction and the inviolability which was then enjoyed by Mr. Yerodia under the principles of international law. Moreover, the court noted that the intentions of the Kingdom of Belgium were to effectively establish a legal basis to arrest Mr. Yerodia, and was thus fully aware of the violations they were committing. Those actions should be engaged to the Kingdom of Belgium's international responsibility. The courts considered that the findings so reached by them constituted a form of satisfaction, which will make good the moral injuries complained by the Democratic Republic of Congo. Taking all this into account, the court ruled the following. 15 votes to 1 rejected the objections brought by Belgium relating to international universal jurisdiction. 15 votes to 1 found that the jurisdiction to entertain the applications filed by the Democratic Republic of Congo was good to the courts. 15 votes to 1 found that the applications of the Democratic Republic of Congo is without object and the case is not moot. 15 votes to 1. The application by the Democratic Republic of Congo is admissible. 13 votes to 3 voted in favor that the fact that the warrant against Mr. Yerodia constituted violation of a legal obligation of the Kingdom of Belgium towards the Democratic Republic of Congo in the way that they failed to respect the immunities from criminal jurisdiction and the inviolability which the incumbent minister enjoyed under international law. By 10 votes to 6, the judges found that the Kingdom of Belgium must, by all means of its own choosing, cancel the arrest warrant of the 11th of April of the year 2000 and so inform the authorities to whom that warrant was circulated. As you can see, not all the judges agreed to the same issues. As a matter of fact, 3 of the judges later on published their own personal opinion regarding universal jurisdiction.
Now we will focus on why is this case relevant in our course of diplomatic law. Diplomatic law is a field of international law concerning the practice of diplomacy and the rights and obligations of state representatives on the territory of other states. If we focus a little bit more, we found that a fundamental concept of diplomatic law is actually diplomatic immunity, which is one of the most relevant concepts in our case. This case is mainly focused around the immunity that enjoys the Ministry of Foreign Affairs of the Democratic Republic of Congo, in this case, Yerodia. According to international customary law, he enjoys an absolute inviolability and immunity of jurisdiction against the Tribunal of Third States, as is a part of, as already mentioned, international customary law. This doesn't mean, as said before, that Yerodia can escape from his crimes or declarations. He's not scot-free, as the court stated, because immunity doesn't mean impunity. The issue here is that even though the court analyzes that he's not immune from his action, there are little possibilities that a country will take measures against its own people, against, in this case, its own Ministry of Foreign Affairs. This have seen before in Srebrenica with the Dutch bath, but this is more of an exception than the rule. At the end, this sentence proves that there is a huge difficulty of put in practice the international norms regarding the criminal punishment for individuals. Because of this, the victims of these crimes against humanity, like for example the ones done in August 1998 in the Democratic Republic of Congo, just have to wait for the evolution of their judicial system that will protect them and give them guarantees that there will be a punishment for the aggressors of these human rights. To conclude, we would like to say that this case is to us a little bit of ironic. This poses a problem to the global multipolar world that we live today. We have a country like the Democratic Republic of Congo, which has violated the human rights regularly, that brings a claim against Belgium, a democratic state that respects the human rights and protects them, due to the violent arrest asked by the courts of the European country against Yerodia, which is the Ministry of Foreign Affairs. At the end, the ICJ concludes that Belgium has committed a wrongful act after trying to arrest an individual due to his acts while being a representative of that state. If we cannot judge individuals because of their actions, if they have immunity, even though these actions are actually considered crimes against humanity which fall under the universal jurisdiction, if they are protected, why should the more developed countries respect those rights?